Former law school professor Cheryl Bader has followed developments in former President Trump's case. She's a former assistant United States attorney and joins us now. Thank you. Good morning, Professor Bader.
Good morning. It's nice to be here.
And were there any surprises during yesterday's arraignment, would you say?
No surprises. Remember, the arraignment is really just the very beginning of the process. We saw the same kid glove treatment that Trump has gotten in his other arraignments. And the judge will ask the parties to submit their proposals for the timeline for the trial. And I think we'll see special counsel being ready to go with his ducks in order so that there isn't any delay, because we know that Trump's strategy is generally delay, delay, delay. And here he may believe that if he can delay this long enough till after the election and then he's in charge of the Department of Justice, that he can make this all go away.
And this indictment, only 45 pages. The Select Committee report on 1/6 was much longer. What do you make of this case being so concise? Could Special Counsel Smith have more evidence or bring a superseding indictment?
So this is called a speaking indictment, which means it actually does lay out a narrative of evidence. And here, I think it was, as a former federal prosecutor, I think this indictment was very well drafted. It educates the public as to what the evidence is. But remember, the prosecutor doesn't need to put all the evidence in the indictment itself. That actually comes out in trial. And so I'm sure that, there will be additional evidence coming out. But I would be very surprised if we see any superseding indictment. You don't need to supersede in order to introduce evidence. It's really only if they want to add additional charges or co-defendants. And I think we see a sort of a purposeful strategy of not having these other, unnamed co-conspirators charged as co-defendants in order to streamline the process. So any superseding of the indictment could cause delay, and I think we definitely won't see that happening. There may be some indictments that could actually already be under seal for the other co-conspirators, but I would be surprised if we see those coming out right now, because I don't think that the counsel wants them to be consolidated again, because his strategy is not to have delay.
When it comes to those co-conspirators, Rudy Giuliani, possibly one of them, what kind of deal could be offered?
So if I'm representing any of those co-conspirators, I'm thinking to myself, there is definitely charges coming down the pike. And I would want to be on Team Smith, because there's advantages to having a cooperation agreement. So that's a deal where the co-defendant would come in and testify and give testimony, and the prosecutor will then stand before the judge and say, this person should get a more reduced sentence and lighter treatment because they came in and they helped us in a case against sort of the bigger fish. And so, that might be going on behind closed doors. Of course, we don't know, right? We don't know if these are individuals that special counsel feels that he needs or wants to have as witnesses. So a lot remains to be seen.
And why wasn't Donald Trump charged with insurrection or sedition? Doesn't our 14th Amendment say office holders can have engaged in insurrection or rebellion? I mean, what are your thoughts about that? Some are saying.
So I think he took a very cautious strategy here by not charging inciting an insurrection. And some of the critics say, he should have, because of this lesser known provision in the 14th Amendment, which does say that if somebody takes an oath to uphold the Constitution and then violates that oath by engaging in insurrection, that they can't hold office later. And so there doesn't have to be necessarily a conviction to trigger that provision. Of course, it always helps to have a jury have decided beyond a reasonable doubt, but it could be enacted even though he's not charged particularly with insurrection. But I think, again, a cautious approach. Trump has been saying this is all a witch hunt and, this is to keep me out of office. And so charging that might have, fueled that argument. Also, it's a difficult charge to prove, right? It opens up a whole messy issue around the First Amendment and whether this was protected political speech. And so personally, I think that special counsel could have established that this is outside of protected speech, because the test is whether the speech was likely to result in imminent lawlessness. And I think that, we saw that it did, in fact, result in that. And I think that test would have been met. But it's an issue around the First Amendment that probably would have gone up to the Supreme Court, again, might have delayed things and just sort of complicates the case. And he was able to get in the violence, the pressure, everything that happened at the Ellipse and with the mob without having to charge that, because he got into the conspiracy count in general. And remember, Trump is the master of parsing his words and selecting his words carefully. And here he was going to argue, I said they should go peacefully. And, I shouldn't be responsible if they interpreted what I said about, fighting, with, giving the good fight, that I really just meant that they should advocate passionately, and not that they should go and assault the Capitol Police. So I think there was a lot of reasons for the decision. And, we'll see if later on that Fourth Amendment provision does get enacted.
Fordham Law School Professor Cheryl Bader, thanks for being with us.
It's good to be here.
We'll be right back.